Rule 137, Opinion Rule, Section 51, General Rule. The opinion of a witness is not admissible except as indicated in the following sections. Section 52, Opinion of expert witness. The opinion of a witness on a matter requiring special knowledge, skill, experience, training, or education, which he or she is known or, or she is shown to possess, may be received in evidence. Section 53. Opinion of ordinary witnesses. The opinion of a witness for which proper basis is given may be received in evidence regarding A. The identity of a person about whom he or she has adequate knowledge. B. A handwriting with which he or she has sufficient familiarity. And C. The mental sanity of a person with whom he or she is sufficiently acquainted. The witness may also testify on his or her impressions of the emotion, behavior, condition, or appearance of a person. 8. Character evidence. Section 54. Character evidence not generally admissible. Exemptions. Evidence of a person's character or a trait of character is not admissible for the purpose of proving action in conformity therewith on a particular occasion except A. In criminal cases. 1. The character of the offended party may be proved if it tends to establish in any reasonable degree the probability or improbability of the accused charge. 2. The accused may prove his or her good moral character pertinent to the moral trait involved in the offense charge. However, the prosecution may not prove his or her bad moral character unless on rebuttal. B. In civil cases, evidence of moral character of a party in a civil case is admissible only when pertinent to the issue of character involved in the case. C. In criminal and civil cases, evidence of the good character of a witness is not admissible until such character has been impeached. In all cases in which evidence of character or a trait of character of a person is admissible, proof may be made by testimony as to reputation or by testimony in the form of an opinion. On cross-examination, inquiry is allowable into relevant specific instances of conduct. In cases in which character or a trait of character of a person is an essential element of a charge, claim or defense, proof may also be made of specific instances of that person's conduct. Rule 131. Burden of proof, burden of evidence, and presumption. Section 1. Burden of proof and burden of evidence. Burden of proof is the duty of a party to present evidence on the facts in issue necessary to establish his or her claim or defense by the amount of evidence required by law. Burden of proof never shift. Burden of evidence is the duty of a party to present evidence sufficient to establish or rebut a fact in issue to establish a prima facie case. Burden of evidence may shift from one party to the other in the course of the proceedings depending on the exigencies of the case. Section 2. Conclusive presumption. The following are instances of conclusive presumptions. A. Whenever a party has, by his or her own declaration, act or omission, intentionally and deliberately led another to believe a particular thing is true and to act upon such belief, he or she cannot, in any litigation arising out of such declaration, act or omission, be permitted to falsify it. And B. The tenant is not permitted to deny the title of his or her landlord at the time of the commencement of the relation of the landlord and the tenant between them. Section 3. Disputable presumptions. The following presumptions are satisfactory if uncontradicted, but may be contradicted and overcome by other evidence. A. That a person is innocent of crime or wrong. B. That an unlawful act was done with an unlawful intent. C. That a person intends the ordinary consequences of his or her voluntary act. D. That a person takes ordinary care of his or her concern. E. That evidence willfully suppressed would be adverse if produced. F. That money paid by one to another was due to the latter. G. That a thing delivered by one to another belonged to the latter. H. That an obligation delivered up to the debtor has been paid. I. That prior rents or installments have been paid when a receipt for the latter once is produced. J. That a person found in possession of a thing taken in the doing of a recent wrongful act is the taker and the doer of the whole act. Otherwise, that things which a person possesses or exercises acts of ownership over are owned by him or her. K. That a person in possession of an order on himself or herself for the payment of the money or the delivery of anything has paid the money or delivered the thing accordingly. L. That a person acting in a public office was regularly appointed or elected to it. M. That official duty has been regularly performed. N. That a court or judge acting as such, whether in the Philippines or elsewhere, was acting in the lawful exercise of jurisdiction. O. That all the matters within an issue raised in a case were laid before the court and passed upon by it, and in like manner, that all matters within an issue raised in a dispute submitted for arbitration, issue raised in a dispute submitted for arbitration, were laid before the arbitrators and passed upon them. P. That private transactions have been fair and regular. Q. That the ordinary course of business has been followed. R. That there was a sufficient consideration for a contract. S. That a negotiable instrument was given or endorsed for a sufficient consideration. T. That an endorsement of a negotiable instrument was made before the instrument was overdue and at the place where the instrument is dated. U. That a writing is truly dated. V. That a letter duly directed and mailed was received in a regular course of the mail. W. That after an absence of 7 years, it being unknown whether or not the absentee still lives, or he or she is considered dead for all purposes, except for those of succession. The absentee shall not be considered dead for the purpose of opening his or her succession until after an absence of 10 years. If he or she disappeared after the age of 75 years, an absence of 5 years shall be sufficient in order that his or her succession may be open. The following shall be considered dead for all purposes, including the division of the estate among the heirs. 1. A person on board a vessel lost during a sea voyage or an aircraft which is missing, who has not been heard of for 4 years since the loss of the vessel or aircraft. 2. A member of the armed forces who has taken part in armed hostilities and has been missing for 4 years. 3. A person who has been in danger of death under other circumstances and whose existence has not been known for 4 years. And 4. If a married person has been absent for 4 consecutive years, the spouse present may contract a subsequent marriage if he or she has a well-founded belief that the absent spouse is already dead. In case of disappearance, where there is danger of death under the circumstances herein above provided, the absence of only 2 years shall be sufficient for the purpose of contracting a subsequent marriage. However, in any case, before marrying again, the spouse present must institute a summary proceeding as provided in the family code and in the rules for a declaration of presumptive death of the absentee without prejudice to the effect of the reappearance of the absent spouse. X. That acquiescence resulted from a belief that the thing it was conformable to the law or fact. Y. That things have been happen according to the ordinary course of nature and the ordinary habits of life. Z. That persons acting as co-partners have entered into a contract of co-partnership. AA. That a man and a woman deporting themselves as husband and wife have entered into a lawful contract of marriage. BB. That property acquired by a man and a woman who are capacitated to marry each other and who live exclusively with each other as husband and wife without the benefit of marriage or under a void marriage has been obtained by their joint efforts, work, or industry. CC. That in case of cohabitation by a man and a woman who are not capacitated to marry each other and who have been acquired property through their actual joint contribution of money, property, or industry, such contributions and their corresponding shares, including joint deposits of money and evidences of credit, are equal. DD. That if the marriage is terminated and the mother contracted another marriage within 300 days after such termination of the former marriage, these rules shall govern in the absence of proof to the contrary. 1. A child born before 180 days after the solemnization of the subsequent marriage is considered to have been conceived during the former marriage, provided it be born within 3 days after the termination of the former marriage. And 2. A child born after 180 days following the celebration of the subsequent marriage is considered to have been conceived during such marriage, even though it be born within the days after the termination of the former marriage. That a thing once proved to exist continues as long as is usual with things of that nature. That the law has been obeyed. That a printed or published book purporting to be printed or published by public authority was so printed or published. That a printed or published book purporting to contain reports of cases, a judge and tribunals of the country where the book is published contains correct reports of such cases. That a trustee or other person whose duty it was to convey real property to a particular person has actually conveyed it to him or her when such presumption is necessary to perfect the title of such person or his or her successor in interest. That except for purposes of succession, when two persons perish in the same calamity, such as wreck, battle, or conflagration, and it is not shown who died first, and there are no particular circumstances for which it can be inferred, the survivorship is determined from the probabilities resulting from the strength and age of the sexes according to the following rules. 1. If both were under the age of 15 years and older, the older is deemed to have survived. 2. If both the age of 60, the younger is deemed to have been survived. 3. If one is under 15 and the other above 60, the former is deemed to have survived. 4. If both be over 15 and under 60, and the sex be different, the male is deemed to have survived. If the sex be the same, the older. 5. If one be under 15 and over 60, and the other between those ages, the latter is deemed to have been survived. That if there is a doubt as between two or more persons who are called to succeed each other as to which of them died first, whoever allege the death of one prior to the other shall prove the same. In the absence of proof, they shall be considered to have died at the same time. Section 4. No presumption of legitimacy or illegitimacy. There is no presumption of legitimacy or illegitimacy of a child born after 300 days following the dissolution of the marriage or the separation of the spouses. Whoever allege the legitimacy or illegitimacy of such child must prove his or her allegation. 5. Presumptions in civil action and proceedings. In all civil action and proceedings not otherwise provided for by the law or these rules, a presumption imposes on the party against whom it is directed the burden of going forward with evidence to rebut or meet the presumption. If presumptions are inconsistent, the presumption that is founded upon weightier consideration of policy shall apply. If considerations of policy are of equal weight, neither presumptions applies. Section 6. Presumptions against an accused in criminal cases. If a presumed fact that establishes guilt is an element of the offense charge or negates a defense, the existence of the basic fact must be proved beyond reasonable doubt, and the presumed fact follows from the basic fact beyond reasonable doubt.